This is Just Results, Indigenous Law and Legal Pluralism in Canada and Beyond, a presentation by Brandy Bowers. As illustrated in the title slide, historic and contemporary issues have led to an environment of systemic discrimination for Indigenous peoples in Canada. Based on a false assumption of terra nullius, or the doctrine of discovery, colonial societies have a tradition of marginalizing Indigenous peoples as a means of justifying European sovereignty and dispossession of Indigenous lands. Archaic and ill-fitting legislation, such as the Indian Act, still exist today and provide a basis on which the criminalization of Indigenous people occurs through a process of othering and subjugation. As quoted by Ross in Returning to the Teachings, Exploring Aboriginal Justice, in 1991, a Cree elder from Alberta remarked, in reference to non-Indigenous justice initiatives, that, "We know you have a legal system, we're just not sure it's a justice system." This sentiment is reinforced through the over-policing of Indigenous peoples, which can make them much more likely to be engaged by police, much more likely to be charged with an offense, and also more likely to serve time as a result of these offenses, serving to widen the economic gap between Indigenous and settler society. During its approximately 100-year history, the residential school system saw roughly 150,000 Indigenous children removed from their homes and forced into schools where they were forbidden to speak their languages and completely disconnected from their culture. The result has been a legacy of pain and suffering for Indigenous people. In spite of a system that continues this legacy by forcing them to conform to Western models of justice and governance, Indigenous peoples in Canada have persevered. One way in which they have asserted their own traditions is through Indigenous legal orders. This existence and practice of multiple legal systems within a shared system is known as legal pluralism. Legal pluralism has been practiced in Canada since its inception, with the use of civil law in Quebec and common law throughout the rest of the country. The provision of space for other legal traditions to exist within one system promotes a sense of legitimacy to the exercising entities and is a step towards renewed relationships with Canada's Indigenous people. Political sociologist Seymour Martin Lepsit argues that groups regard a political system as legitimate or illegitimate according to the way in which its values fit with theirs. This assertion can be examined on multiple levels. From the point of the Canadian state, the dismissal of Indigenous law provides an assertion of power. From the standpoint of Indigenous nations, the cultural mismatch between the liberal and Indigenous worldviews serves as a source of distrust. Gordon Christie juxtaposes liberal theory, which is individually focused and incapable of reconciling collective rights, in opposition with the rights of the individual. Law is the vehicle used to ensure individual rights are prioritized over collective rights, and we see this played out in precedent-setting Indigenous rights cases such as the Sparrow case. While this case upholds the Indigenous rights entrenched by Section 35 of the 1982 Constitution, it also confirms that these rights are not absolute by introducing a test which the courts can apply to determine if infringement of Indigenous rights can be legally justified. In contrast to liberal theory, Indigenous theory is based around collective rights of the community, seeing individuals as nodes within a web of interconnecting strands that outline roles. Identity is based on roles and responsibilities within the community, not individually defined. By understanding this cultural mismatch, we can see how existing within the Canadian system, which is held up as superior, serves to subjugate Indigenous values and belief systems, and ultimately Indigenous people themselves. One of the benefits of adopting Indigenous law as a form of legal pluralism is that it allows us to break down common myths. The colonial narrative would have us believe that Indigenous peoples were lawless and uncivilized. This strengthens the claim of Crown sovereignty. Indigenous law is often also presented as perfect or sacred, leaving little room for growth and change, which is not the case. Indigenous law, just like Canadian law, is malleable and adapts to time and place. The process of creating an environment with space for Indigenous law allows for a greater degree of understanding in Canadian society and leads to a breakdown of myths and misconceptions. Indigenous law is carried through stories and teachings, which have the ability to transcend time and place. As oral traditions, Indigenous law is rooted in Indigenous languages, which are often relational and action-oriented, focusing on roles and responsibilities. For these reasons, Indigenous law becomes more accessible through an individual's understanding of their obligations to others. In his report for the Law Commission of Canada, Indigenous legal scholar Dr. John Borrows provides examples of legal traditions from a number of Indigenous groups, each with their own unique laws and traditions. Regarding Cree legal traditions, he says, Cree law contains many fundamental principles. One of these is Mi'otsitwen, which is said to have originated in the laws and relationships that the Cree Nation has with their creator, and directs Cree people to conduct themselves in a manner such that they create positive relations in all relationships. From the root meaning to come alongside or to support, Mi'otsitwen is often represented by the circle in Cree law. Circles are considered sacred and represent the bringing together of people. They are meant to remind people of Mother Earth and their journey through life. It is also interesting to note how Cree and many other Indigenous legal traditions provide visual representations that are likely to occur in daily life, such as the circle in the case of Mi'otsitwen, or animals in many stories as a means of serving as reminders and further reinforcing that idea of accessibility in Indigenous law. Borrows goes on to explain a contemporary application of Cree linguistic concepts in Canadian law, as found in Saskatchewan's provincial court. The Cree court creates an important space for Cree legal traditions to find expression. All proceedings of the court are conducted in the Cree language. While Canadian law forms the basis of the court's jurisdiction, its focus can be different from conventional provincial court proceedings. When proceedings are conducted in Cree, the dynamics of the legal process are different. Linguistic relationships are possible that are not easily comprehended in English. Borrows cautions that while the Cree court is an important initiative, it does not represent anything close to a fully functioning Cree legal system. The substance and procedures of Canadian law continue to contain many cultural incongruities that are considered incompatible with Cree legal traditions. While I have focused on Indigenous law within Canadian society, these concepts certainly have a much broader current and future implications throughout the world. In a paper entitled When Legal Worlds Overlap, Human Rights, State and Non-State Law, the International Council on Human Rights Policy explores the concepts of legal pluralism in the global context. The opening statements of the document provide a basis for understanding legal pluralism within a framework of global citizenship, stating, given the concerns surrounding the failure of most state legal systems to ensure effective access to justice, particularly for marginalized and vulnerable communities, a range of actors, using a range of arguments, have encouraged or demanded the introduction or recognition of plural legal orders. Perhaps one of the most important things to remember when thinking about legal pluralism is that there is not a single template that can be used globally. There are countless instances of legal pluralism throughout the globe, each with its own nuances. For instance, in Lebanon, each of the 18 state-recognized religious communities has its own court, with exclusive jurisdictions over laws governing matters of family, marriage, and succession. In India and Bangladesh, different religious communities have their own personal laws, some codified and some not, that govern many aspects of marriage and family, though all cases are heard in a unitary court system. In Malaysia, a person's religious identity automatically determines which law governs his or her family disputes, whereas in Cameroon, a person is free to choose whether family matters are governed by customary laws or by general civil law, which is open and applicable to all. Creating space for many different legal systems to coexist can promote a more equitable environment. Subordinating one system to another creates a hierarchy and creates value judgments within society. The benefits of legal partnerships are twofold. First, it sends a message to society that we are all on equal footing, assisting in the breakdown of biases, leading to an eventual paradigm shift. Second, it allows healthy interaction between systems, creating a space for learning and adaptation. No single legal system is perfect, but providing space for people to learn from one another in a more open and cooperative environment can not only allow for better hybrid systems to emerge, but also strengthens relationships between different communities. Although we can envision how a legally pluralistic society could provide a more equitable space for a diversity of people to coexist, it is not without its pitfalls. Deciding when and to whom which legal processes apply is a major challenge, particularly as it relates to things like culture and belief systems. The application of different processes based on a person's membership or lack of membership has a potential to limit rather than uphold a person's human rights. Another criticism of legal pluralism and some Indigenous legal traditions themselves are challenges to equal human rights, particularly as it relates to gender equality. In the brief video produced by the University of Victoria entitled Indigenous Law, Gender, and Sexuality, this issue is discussed in the context of Indigenous law. Dr. John Boros tackles this issue, reminding us that Indigenous law is not frozen in time, and using stories which transcend time and place to make decisions allows for an examination of the issues in a contemporary context. Essentially, this points to the need for law in any tradition to have the capacity to grow and evolve with the times, which I believe underlines the need for a global citizenship perspective that creates space for individuals from a diversity of legal perspectives to support one another. To wrap up this presentation, I want to leave you with a quote by Audre Lorde, which I believe provides further context to the issue of legal pluralism and how it applies to the topic of global citizenship. Lorde says, "The master's tools will never dismantle the master's house." To me, this reminds me of the way in which imperial expansion and colonization has created gaps in rights and privileges throughout the globe. In recognizing and lending proper attention and legitimacy to alternative forms of legal orders, we send the message that Western values and ideas are not superior. In providing alternative perspectives to the legal world around us, we are better able to reflect on our own society's practices, which may lead to more questioning and evaluation of these practices. It is only through self-reflection that we will see true change. Thank you for joining me in this brief exploration of Indigenous law and legal pluralism. If you want to learn more about this topic, please check out these excellent resources which I drew my information from. Thanks.